why doesn't Smiley stand for maybe a broader but simpler proposition, which is when we think about this word legislature, we're thinking about it as embedded in a system of constraints. And one of those constraints is the governor, and another of those constraints is the courts. And that's the normal way that legislatures operate and act, is as subject, not as absolute, but as subject to constraints. And Smiley said, we take that system as we find it. We take the constraint of the governor as we find it. Why not, too, then, the constraint of the courts?
We agree, Your Honor, the constraint of the court applying federal law. That's the teaching of Palm Beach County as we read that case. There was a vacatur of the Florida Supreme Court to send it back after having cited—
But it would be ordinary constraints, and the constraints can come from the federal Constitution, or the constraints can come from the state constitution. State actors, state courts operate in both spheres and do both things. And that's the ordinary operation of the courts. And that's what Smiley says. It's the legislature subject to the ordinary set of constraints that operate on them.
We read Lesser to teach that when it's the ordinary constraint is federal law, that it's bound by federal law. That's the ordinary constraint.
Well, if that's coming from Lesser, I mean, so then you're going to sort of our precedent. And I would think that our precedent gives you a lot of problems. I mean, if you really take every statement that this court has said about the matter at hand, I'll just read you a few of them, and they're pretty recent. You know, Smiley is the one we've been talking about, and that says, just as Congress is subject to limitations in the federal Constitution when it makes laws, and now I'm quoting, there is no intimation of a purpose to exclude a similar restriction imposed by state constitutions upon state legislatures. And then in Arizona, we say nothing in the Elections Clause instructs, and this court has never held that a state legislature may prescribe regulations on the time, place, and manner of holding federal elections in defiance of provisions of the state's constitution. And as to that point, the dissent was right with the majority. So both of them took issue with the proposition that legislatures would exercise their authority without the constitutional checks that a state court provides. And then in Rucho, 3 years ago, the court assured everybody in a case very much like this one. It was a case about gerrymandering. And it says complaints about districting need not echo into a void because provisions in state statutes and state constitutions can provide standards and guidance for state courts to apply in addressing gerrymandering. So 1, 2, 3, in all recent cases, we've said, of course, state courts applying state constitutions typically constrain state legislatures when they redistrict, when they enact election laws.
Let me start, if I may, with Arizona, Your Honor. In Arizona, the plaintiff was the Arizona State Legislature. The Arizona State Legislature did not make any complaints about the substantive restrictions in that referendum, and it's not clear it would have had Article 3 standing to complain about a constraint being placed on a different entity. So nothing in this court's decision went to the substance that was in that.
Yeah, I guess what I'm saying is that in each of these three, we have very clear statements, and I appreciate the fact that this issue was not the one before us in each of those three, just as it wasn't in the case that you mentioned to me that started off my quoting other things. If you're going to quote one at me, I'm going to quote 3 at you. And you're right, we're here for the first time dealing with this issue. This is a novel challenge. So I'm not saying that we've sat here as a court and addressed hundreds of pages of briefing on this challenge. I'm saying that 3 times in not so many years, we've understood this to be an established proposition of law.
So, Your Honor, let me now address Rucho, the most recent, where this court said, quote, we express no view close quote, on these policy proposals. And many of the policy proposals that were identified in Rucho are ones that are fully consistent with the line we are drawing. The Rucho majority pointed to statutes in Iowa and Delaware that banned partisan gerrymandering. The Rucho majority pointed to a constitutional amendment in Missouri that designated and created the office of a state demographer to draw state lines. And essentially that's what we have here in North Carolina. Partisan gerrymandering has now been banned at the state level for the state races, and we're not here challenging that, and that presumably will have a salutary influence if the actual legislature itself is not gerrymandered. Then when it comes to the role of doing congressional races, and there were referendum, independent commissions were referenced by the Rucho majority, and we're not debating that. And Congress just this session, the House of Representatives, which has more at stake than the Senate in terms of redistricting, passed a bill that would have banned partisan gerrymandering in all 50 states. And that's what the founders envisioned the solution to this problem was a political solution, going to Congress. It's right there in the text.